Well, greetings, friends. This is Michael Swain, Executive Director of Freedom of Religion South Africa for SA, and we are here with another weekly update, and I am interviewing our Head of Legal, Liesl Pretorius, who has been doing a tremendous amount of work on the new marriage bill, getting ready for 4SA's submissions on that. And as you know, this has been a significant issue that we've been engaged with both at a policy level and, of course, since this bill has actually appeared before Parliament. And it is a proposed new law that seeks to update and overhaul South Africa's current marriage legal system. So, Liesl, without more ado, what is the background to this new marriage bill? What is its purpose? And maybe you can let us know how it came about.
Well, Michael, very briefly, the purpose of the marriage bill, this new marriage bill, is to consolidate South Africa's marriage law system. Our current system is very fragmented. We have three pieces of marriage legislation. First, there's the Marriage Act, which caters to traditional heterosexual one man, one woman monogamous marriages. Then we have the Civil Union Act that caters to also heterosexual but also same-sex unions. And then we have the Customary Marriages Act that caters to traditional African marriages that might be polygamous as well. And then, of course, which is what is very concerning from a freedom of religion point of view, is that we have certain religious marriages that are not yet recognized by law. So this new bill seeks to address the gaps in the current legal system. And how the bill came about is that the Department of Home Affairs, who is the custodian of this bill, was now before Parliament, but they initiated the process. They set about an extensive public engagement process, and I really want to commend them for the quality of the public engagement that they had. Across national, provincial engagements, and they produced the green paper, and then from there, the final white paper, which is an official policy document setting out the policy positions and recommendations that came out of this consultative process, and then they produced a draft bill. The bill has now been tabled in Parliament. So just a distinction, when a bill is in its concept form still before a department, we call it a draft bill, and then it gets tabled and it's called a bill of Parliament. So that is the process that went before, and where we are now is that we have this new marriage bill before Parliament that will hopefully address all the concerns of our current marriage law system.
Yes, as we often say, for SA, we are faith neutral. And obviously, this law is designed to protect the rights to religious freedom of all South Africans. That's been our interest in it from the beginning. That's really where we've been pushing. We focus on the religious freedom dimension. So, Lisa, what's your overall impression of the bill?
Overall, from this faith-neutral position that we have, Michael, I would say it's a very good bill. Because it broadly protects religious freedom, and it broadly protects other viewpoints as well, but it broadly protects religious freedom. It balances constitutional rights in a reasonable way. So I think overall, it's a very good bill. Unfortunately, there are one or two, we'll focus on that later, two problematic aspects that need to be addressed. But overall, I think the department did a very good job at producing something that reflects the South African landscape and that takes into consideration the rights and freedoms of people in South Africa as far as marriage is concerned.
Yes, we were very, I think, commending of it, because it was quite a difficult juggling act. Because obviously, when it comes to marriages, on the one hand, the state has a very clear interest, because a marriage is a lifelong, let's say, contractual relationship. And within a marriage, you obviously have property rights come into play. Children usually or often happen. What happens when you get a divorce? What happens when one spouse dies? In other words, the state needs to know that this is a legitimate marriage that has been contracted. And so they had certain elements that they wanted to make sure were obviously legitimized at the point of marriage, so that they could be certain on that. But they kind of separated in that sense, I think, and wisely so, the sacred from the secular. So the secular is obviously what they wanted to know, but the solemnization aspects of it, that was where they gave a lot more lateral than perhaps had existed previously. So, Liesl, maybe you can elaborate a little bit. You know, you obviously said this is a good piece of legislation. What aspects of the bill do we support, and maybe you can unpack that?
Certainly. Well, first, let's look at religious marriages. So, a welcome aspect of this bill is that it recognizes religious marriages, subject to minimum criteria that are very reasonable. For example, do the parties consent to the marriage? Are they the required minimum age? Are they witnesses? So, very basic, very minimum criteria, because we want to know if there's a legitimate marriage, and we don't want people forced into marriages, and we don't want minors forced into marriages. Then there's an express protection of the religious freedoms rights of religious marriage officers, and per extension also the religious organizations to whom they belong. This is very important. This is what came through in the white paper, and surprisingly it wasn't included in the draft bill. So the bill before the department, there wasn't this express protection. We have this express protection also in our current Marriage Act. And when we created this on the draft bill, the department they said that, well, it's implied, and we said no, you can't have this implied. It needs to be there expressly, because if it was there expressly previously and then it gets left out, it might create the impression that that protection shouldn't be there. And if that protection is not there, it would be a gross violation of the religious freedom rights of religious marriage officers and religious institutions, not to be forced to solemnize any marriage that does not accord with their beliefs, their convictions, the tenets of their faith, the doctrines, and the disciplines of their institution when it comes to marriage. So that is included in this bill that's now before Parliament. That's a very positive development. Then another positive development is the categories of people who can become designated marriage officers are extended. So it's not only religious marriage officers. Now other cultural and secular groups can have their own religious marriage officers, which is much more democratic, because now every group has somebody that caters for them. So nobody can then potentially say, well, there's nobody that can solemnize marriages according to what we believe, according to our worldview. That category has now been opened. So the onus is then on the public or cultural or religious organizations to have the people who want to be designated marriage officers to go through the process and become designated marriage officers.
Yeah, I think that to me, I mean, I think a big win for SA and of course the public participation process was the fact that this express clause protecting religious marriage officers from not being forced to solemnize marriages which went against their conscience and beliefs, that is now in firmly, and obviously we need to keep sustaining that and supporting that as this bill goes through Parliament to the next stage. And maybe, Liesl, it's also good to mention that we do realize, of course, that there are some who are concerned about the redefinition of marriage in this instance and would like to see that word restored to its original meaning of a lifetime relationship or partnership between one biological man and one biological woman. That has not been 4SA's fight, but we do obviously accept that people, when it comes to this marriage bill, may have other objections than the one that we do. But maybe you could also mention, like, what are our residual concerns that we have about this bill? Because there are still a couple of problematic aspects that we see in it.
Yes, Michael, our remaining concerns are twofold. This relates to the ex officio marriage officer. So this is a civil servant marriage officer, a person who's employed by the Department of Home Affairs, a magistrate, and certain other people who, due to their job, which is not related to marriage, but due to their job, they can also be a marriage officer. And then there's a concern, but we can unpack that a bit later. And then there's also a concern about the door being inadvertently open for the criminalization of religious ministers who are not designated marriage officers in terms of marriage legislation, that conclude the religious ceremony part of a marriage, but not the formal legal part. We don't want to see them inadvertently criminalized when they're not trying to conclude a fraudulent marriage, for example. And those are aspects that we still need to address.
Right, and addressing them, indeed we are. Liesl, I know you've been doing a lot of work on this, so maybe you could just unpack what 4SA is now doing in this next phase and stage of this bill and how it's now being processed through Parliament.
Yeah, so the first way that we've addressed our remaining concerns is through our written submissions that we already submitted to Parliament in April or May this year. And then we have upcoming public hearings that are scheduled at the moment for the 10th and 11th of September before Parliament, before the Portfolio Committee on Home Affairs. So first of all, we're going to emphasize, the things that we want retained, for example, that express protection of religious marriage officers. But as to those two concerning remaining aspects, let's start with the ex officio marriage officers. We need to protect the religious freedom rights of the basis, specifically the conscientious rights, the conscience rights of ex officio marriage officers, because you don't leave your freedom of religion behind when you go to work in the morning. And we are not a secular state in the sense that religion is welcome in the public sphere. And we believe that as a sign of a mature democracy, we can maximize the human rights, including religious freedom rights of all people, without undermining anybody's equality or human dignity. So one way to ensure that we can do this is, for example, that ex officio marriage officers, that we separate the solemnization aspect of a marriage, because solemnization, if you look at the dictionary definition of the word, it has necessarily a religious meaning to it. It's very ceremonial. Separate that aspect of the marriage from the administrative, formal, legal part of the marriage. When we say administrative, formal, legal part of the marriage, that's the registration part. It's like registering a birth or a death. There's no religious ceremony aspect to that. And that's actually, as you said earlier, that is reflected in the white paper. We don't understand why that's not reflected in the bill, because that would be such a wonderful addition to the bill. It would be such a win for democracy, because the religious freedom of your civil servant marriage officer would be protected, while at the same time, the state can ensure equal quality service delivery in terms of marriages to all people in South Africa on an equal basis and without diminishing anybody's human dignity. So that would really be something positive that we can change about the bill, that concerning aspect. And then the other aspect.
I think just to jump in on that one, I think that is such a key thing, because, as you say, I think it's reasonable for the public to expect state-employed marriage officers, civil servants, to actually do the, let's say, formalization aspect. But it is not reasonable to expect those people to be forced against their conscience and belief to actually do the solemnization aspect. And I think that's where we need to hold the line. You will recall we fought a similar battle when there was an amendment to the Civil Union Act, which basically stripped marriage officers of their conscientious and religious freedoms and forced them to do the solemnization. So we're hoping that this particular bill and this next, let's say, dimension when we're engaging with it will actually help us to reinforce that and to bring back those protections, which, by the way, were originally mentioned in the judgment that actually opened up this whole space for same-sex marriages, where I think it was Justice Albie Sachs said that there could be a reasonable accommodation of state-employed marriage officers' religious freedom rights. So let's hope that we get back to that. That's certainly what we're going to be fighting for. But yes, Liesl, and the next point you were mentioning.
Yes, I just want to say our democracy would be richer for that. If we could go back to that idea envisioned by Justice Sachs in the Fareed judgment, if I'm not mistaken,
yes.
Where we have equal service delivery and recognition, but without diminishing the fundamental rights of people who take their religion and they to also want to live out their religion in the workplace and not be forced to do anything against their sincerely held beliefs. So the second point I mentioned was the inadvertent criminalisation of religious marriage officers who perform only the religious component and not the legal component of a marriage ceremony. So what is this? This is, for example, let's take, for example, of a pastor. A couple, they have a specific pastor that they have a good relationship with. They want this pastor to marry them. This is the pastor appointed in the church where they go. This pastor is not a designated marriage officer in terms of the marriage legislation. So they know that this pastor cannot legally marry them, but they have a marriage ceremony and the pastor does the sermon and the religious part for the couple. And then there's another pastor of that organization or another organization that is for a designated marriage officer in terms of the marriage legislation. And that pastor, who is the designated marriage officer, the religious marriage officer, does the formal write in the register and all the paperwork for the Department of Home Affairs. The way that the Act is currently worded, the first pastor, even though this pastor is not pretending to be a marriage officer, and the couple knows that, and they have the properly designated marriage officer also there, or maybe, the day before they went to the Department of Home Affairs to get their marriage registered there. We don't want this past inadvertently to be criminalized for, being conducting a fraudulent marriage. If we don't think that's the intention of the bill as it is written,
Yeah.
but the wording opens up that possibility. So that's just something that can be easily tightened, for example, by just rewording and putting in definitions and things that can sort it out. So basically, those are our two concerns. And as I said, we will be addressing them in our oral submissions that at the moment are scheduled for the 10th and 11th of September.
No, that's wonderful. That's wonderful, Liesl. As you say, the devil is often in the definitions, and we have to be very careful. And that's obviously where we have, I think, a considerable amount of expertise, is actually helping to make sure that laws particularly don't say things that they're not supposed to be saying. And that would be one such thing. So we're certainly going to be all with you when you're making those submissions and standing before Parliament in that sense. And so just maybe jog us through the process. What are the next steps that's going to actually take place with this marriage bill?
Okay, so our marriage bill is currently before Parliament. Let me just backtrack and just give the whole history, I think, to help orientate people. So it was introduced in Parliament in December 2023, and then in April, the Portfolio Committee on Home Affairs, which is the Portfolio Committee in the National Assembly, the first House of Parliament, that is currently processing this bill. They invited public comment, and we submitted written comments during April, May. And then, of course, in May, our sixth Parliament dissolved, and then the bill lapsed, and it was revived in July, because the new parliaments, they revive all the old bills that lapsed, and this bill was one of them. So what has happened in August this year is that the Department of Home Affairs has briefed the Portfolio Committee on Home Affairs on the bill, and the Parliamentary Content Advisor and Researcher has also briefed the committee on the public comments received. And the Portfolio Committee has now invited the public to attend or make presentations during the public hearings scheduled for September. So after the public hearings are concluded, the committee members of the Portfolio Committee on Home Affairs, they need to sit and they need to study the bill. They need to go through all the comment received, both written and oral. And then will deliberate the bill clause by clause. And they can accept the clauses as they are, they can reject the clauses as they are, or they can propose amended clauses. And then the bill gets passed adopted by the committee, because I don't see that this bill will be rejected by the committee. It will be adopted as is, or in an amended form, hopefully amended with those improvements that we will be contending for. Then it will go to the plenary sitting of the National Assembly, the first house. So a plenary sitting is when the whole house sits together, they vote on the bill. Then it passes to the second house of Parliament, the National Council of Provinces. And then you'll have a similar process with the committee inviting comments, maybe having public hearings, considering the bill. And then once it goes through plenary in the second house, and they also pass a bill, and basically that would mean that the whole Parliament passes the bill. It will go to the president for assent. So we're looking at still a couple of months, maybe end of the year, maybe early next year. There's still a way to go, but the most important thing next up is those public hearings.
Yeah, and I think that our view certainly is it's going in a good direction, which is great, and it's something that we've been pushing for. So Liesl, thank you so much for all the hard work that you've done, and for those of you who are watching this video, please stay informed, stay in touch. We can be easily found at our website, forsa.org.za. We have a Facebook page, Freedom of Religion SA. If you're watching this, you may well be watching it through our YouTube channel. So there's always a weekly update that we try to put up there. But please do support FORSA. We can only do what we do because of those people who actually support us financially, partner with us, so that you can keep us really doing this critical work that we do to defend our rights to faith and freedom. So thank you very much. And until the next time, we wish you very well.
Good day. This is Nobukosi Zulu, legal advisor at 4SA. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.